Hello everyone. Good morning. This is Priyanka from CS Priyanka's Profession Classes. Welcome to my channel. Today my topic is debenture, but this is syllabus specific. I also included the Amendment Rules 2019. I will request only to the CMA intermediate students to check out this video because I have made this video syllabus specific, so it's not for all professionals. But yes, if any topic is common for other professionals, they can check out. Otherwise, it is specific for CMA intermediate people. Hope it will be beneficial for you people. And let's get started. Next is the meaning of debenture. What do you mean by debenture? So I would like to say debenture is a security like stock bond, and it also helps the company evidencing debt. That means whenever company takes loan from the bank, they need to give some security. Okay, and that security, if you're giving the movable security or movable property, we called it's like you were doing the pledge. And if you're providing immovable property, we called it as a mortgage. So now debenture is a movable property, and you can provide debenture while taking loan, though it's evidencing debt. So it's a type of a pledge also, you can say. So obviously though it is a movable property, it's a freely transferable from one person to another. And yes, whenever you will provide debenture in the form of security, you have to follow the manner rules whatever is mentioned in the article of association of the company. So we all know the company runs its business as per MOA and AOA of the company. So whatever is specified, the manner mentioned as per that rules and regulation, debenture is freely transferable from one person to another, from one place to another. So this is what we called this is the meaning of debenture. Next is issue of debenture. So special resolution needs to be passed at general meeting only in case company is issuing the debenture with an option to convert such debenture into shares. So if you are having any future plan to convert such debenture into shares, if it is a convertible debenture, then it's a mandatorily company needs to pass special resolution at the general meeting. So passing special resolution means you need to take the approval from the shareholders that you are issuing debenture, that also with an option to convert into shares. Okay. A non-convertible debenture means need not require special resolution to be passed at general meeting. But if there's an option to convert such debenture into shares, such debenture at the time of issue of such debenture, special resolution passing special resolution is mandatory. Now also as per Act, whenever we are passing special resolution for something, we have to uh, file MGT 14 with the ROC just for the intimation purpose. So here also, while you are passing the special resolution at the general meeting for the issue of the debenture with an option to convert such debenture into shares, you have to file MGT 14 with the ROC for the intimation of such issuance of the debenture in your company. So rule, next is rule. Whatever is mentioned about debenture, this is fully regulated by this company's share capital and debenture rules 2014. Okay, and that is also as per rule 18 subsection 1. Now recently one amendment came, that notification dated 16th August 2019, that passed by the parliament, and which the central government notified that a new rule, that is we called it like companies share capital and debenture amendment rules 2019. So further some amendment and some changes they inserted here, that also we are going to discuss at last. So these two rule you means you should take into the consideration while you are preparing for this chapter. Next is redemption of debenture. What do you mean by the redemption of debenture? That means company will pay the amount of debenture. Okay, so redemption of debenture means just the payment of the amount of debenture by the company, and debentures are redeemed, that is allowed in the corporate on the, so that means like liability on account of the debenture. So whatever money is there, that can means that payment is means will be done by the company to such person or to the debenture holder. And the date of the redemption as per act shall not exceed 10 years. So the company will pay the amount, shall pay the amount within 10 years. That should not exceed 10 years. Okay. In case of preference, redeemable preference share, we have read like 20 years the maturity. So here it is 10 years. But the company which are engaged in the infrastructural project, or you can say their main work is real estate, finance companies, any type of financial companies, non-banking financial companies, they can issue, if they issue secured debenture, okay, they can, their time period, like they can't issue secured debenture exceeding 10 years, but that should not exceed 30 years. But normally the date of redemption of debenture should not exceed 10 years, but only for this type of companies which are involved with this infrastructural project or finance or non-banking financial activities. In such cases, 10 years can be exceeded, but that maximum period will be 30 years in case of redemption of debenture. Next is procedure of issue of debenture. Whenever a company wants to issue debenture, these are the procedure they have to go through, like they have to follow this process. First of all is passing board resolution at board meeting. All the board of directors will pass the resolution that they wants to issue the debenture in the company. After that, the same needs to be approved by the shareholders. For that, special resolution needs to be passed at general meeting. If the company is a listed company, then obviously you have to take the approval from SEBI, Securities Exchange Board of India. After that, you have to check the credit rating. Okay, you have to check the credit rating from the credit rating agency that your company is in what rating. Next is you have to enter into the trust deed with the trustee of the debenture. Trust deed. Trustee, we will come later. We will discuss in the next slide. So trust deed is one of the important thing we have to enter into before issuing debenture. After that, issue a prospectus. Prospectus will be issued by the company just to intimate that they are going to issue the debenture. So that it's like an invitation to the others. Like if anyone wants to, if anyone wants to hold the debenture, they will come and will contact with a company who wants to issue debenture. For that, company will issue the prospectus. After that, they will receive the applications from the people who will be interested in holding the debenture and investing in exchange of debenture. After that, company is going to allot the debenture to them. Whenever they're going to allot the debenture, whenever they're going to get the money from them, they're going to issue the debenture certificate. So company will issue the debenture certificate to the holders, okay, for holding such debenture of the company, and in exchange they have invested in the company. And finally, there is a register of debenture holder in the company. You have to make the necessary entries there. That is also mandatory because there is a compliance. You have to keep in the registered office for minimum 8 years. These are the procedure you have to follow while issuing the debenture by a company. Now we are going to talk about debenture trustee. Who is actually the debenture trustee? So in the debenture, when the company is issuing debenture or when the company is dealing with the debenture, during this situation, company needs to appoint one person as a debenture trustee uh, who is going to take care of these things as per rules and regulation. So debenture trustee is one of the important concept in case the company is issuing debenture. And for debenture trustee, you have to follow certain rules, certain things. For For example, like a company shall appoint debenture trustee before issuing prospectus. So before company is issuing prospectus and intimating about its issuance of the debenture to the outsiders or to the holders, first they need to appoint one person as a debenture trustee. And company, after appointing the debenture trustee, need to obtain the consent from such debenture trustee that yes, he wants to work with you or he wants to work with such company as a debenture trustee. So his written his consent should be in writing, should be submitted to the company that yes, he also agreed to work as a debenture trustee. This is the second thing. First is company will appoint such person debenture trustee before issuing prospectus. Secondly, written consent needs to be obtained from such debenture trustee. So whenever you got the consent from that trustee that yes, he wants to work as a debenture trustee for your company, immediately company needs to enter into a trust deed with such person. So we called it debenture deed shall be executed just to protect the interest of the debenture holder. So there will be the terms and conditions, rules and regulation will be written in that deed. It's a it will be telling it is just made for the protection of the debenture holders, and it should contain the terms and condition of the debenture trustee with the company. Next is the name of the debenture trustee. Whenever the company will issue prospectus or letter of offer, that in that what happened, or they are offering that they are issuing debenture that they wants to intimate to outsider. Okay, for that either they will issue prospectus or else they will issue letter of offer. So whatever they issue there, it's a mandatorily they needs to mention the debenture trustee name. Okay. Now, debenture trustee will work as a debenture trustee, like he will deal with the debenture holders, he will conduct the meeting of the debenture holders, he is going to directly communicate with the debenture holders as per rules and regulation, as per rules, whatever we said, like companies share capital and debenture rules 2014, amendment 19, whatever is that, he will just make sure that everything is okay as per rules and regulation. Now, obviously, whenever he got appointed by the company, whenever afterwards, if there is any problem happens or arise between the debenture trustee and the debenture holder, then obviously debenture trustee can be removed from his position. But yes, one condition will be there, like debenture trustee can be removed from his place by the debenture holder only, not by the company, before the expiry of his term also, only if it is approved by the holder of not less than 3/4 in the value of the debentures. So at least that minimum person is required, that minimum number of debenture holder is required who is not holding less than 3/4 of the value of debenture. They means all total that a full team of the debenture holders can pass a resolution and can if the not less than minimum 3/4 of the value of debentures are held by those debenture holders, they can remove the debenture trustee in case if they feel that debenture trustee is unable to discharge his function properly, then they can do so. Next, like whenever company is entering into a trust deed with a trustee, debenture trustee, uh, what they will do, trust deed obviously in the form sh12 uh, will shall be executed by the company. Okay, whenever by the company issuing debenture in favor of debenture trustee, that is also within 3 months of the closure of issue of offer. So like I know that company needs to appoint debenture trustee before issuing debenture or before issuing prospectus itself. So obviously they have to maintain, like whenever the company will enter into a trust deed with a trust uh, debenture trustee, they needs to file a form sh12. Okay, and there all the details of the debenture trustee will be there, and needs to be filed within 3 months of the closure of such issue of offer. So whenever you are issuing the offer, from that date within 3 months you have to comply this thing, that you have to file sh12 with the ROC by intimating that this person is your debenture trustee and this is the trust deed, these are the terms and conditions, signature, his identities, everything you need to intimate. That is also within 3 months of the closure of the issue of offer. So these are the points you have to remember while you are writing about the debenture trustee of a company. And debenture trustee is a very important topic in exams because sometimes it comes from this chapter. So because he plays a very important role in a company, because he is a separate person who deals with the debenture portion only. Next, we will talk about like the persons who cannot be appointed as a debenture trustee. So normally we knew okay, any person can be appointed as a debenture trustee by the company, but some persons are restricted from that list. So who cannot be appointed or who may not be appointed as a debenture trustee? These are the list. First of all is beneficiary holds shares in the company. So if any beneficiary is there who is holding share of the company, such person cannot be the debenture trustee of the same company. Next is your company's promoter, director, KMP, key managerial personnel. Who are coming under KMP? Like CFO, CEO, CS, CA. All these people are coming under the key managerial personnel of the company. Okay, so if the promoter, director, KMP of your actual company, holding company, or your subsidiary company anywhere, this person are also restricted to be appointed as a debenture trustee. Next is that any person who is having a relation with that company amounting to 2% or more of his gross turnover or total income of rupees 50 lakh or such higher amount as may be provided, whichever is lower during the last 2 financial years. So you have to check the last 2 financial year. So such person, if he is having any type of relation with your company and all total his at least his income of 50 lakh rupees he is earning from your company only, or else 2% of its gross turnover of is his income, or it's he used to get the money from your company. So if it's if such relation is there with such person, then such person cannot be appointed as a debenture trustee. So that if any person is having any monetary relation with your company, and that also limitation is there, like 2%, okay, or more, I'm talking about, like if such person earns 2% or more of its gross turnover from your company only, or else total income of 50 lakh or such higher amount he is getting only from your company only, then in such cases such person cannot be appointed as debenture trustee. And already we have read in the second point that promoter of holding or subsidiary company cannot be appointed as debenture trustee. Same in the point number 4 it is written any relatives of such promoter is also cannot be appointed as a debenture trustee. So these are the list to whom you cannot appoint for your company as a debenture trustee. So next, what are the duties of debenture trustee? Debenture trustee actually appointed in a company just to deal with the debenture holders. So first and foremost duty of the debenture trustee is to communicate properly with the debenture holders. Secondly, in case if there is any default payment of interest, or is there is any default in relating to creation of security for debenture, or any dispute is there relating to redemption of debenture, then second duty and or function of debenture trustee to appoint a nominee director, and nominee director will deal with all these disputes. Thirdly, debenture trustee is going to convene the meeting, communicate with the debenture holders, will conduct the meeting, and will do the necessary things whatever is required to hold a meeting of a debenture holders. Next is the next duty of the debenture trustee is to make ensure that whatever company is doing as per law, as per rules, or as per rules, debenture rules. Okay, so that is going to be ensured by the debenture trustee, that company does not commit or does not committed any type of breach of terms of issuance of debenture. That is a work of debenture trustee to look after. And finally, debenture trustee is going to satisfy himself relating to the content in letter of offer, because Debenture trustee is appointed before the issue of prospectus or letter of offer. So after appointment of debenture trustee, whenever debenture trustee will come, debenture trustee is going to prepare the prospectus or letter of offer. So whether the content in the letter of offer is okay or not, that is actually needs to be confirmed by the debenture trustee. So these are the duties of debenture trustee. Next, I would like to explain the procedures for conversion of debenture into shares in brief. So, we all know that debentures can be convertible or can be converted into shares. So, what are the procedure for conversion of such debenture into shares? So, let us quickly check the points. First of all is board resolution needs to be passed at board meeting. After passing board resolution, we need to pass the special resolution at the general meeting to take the approval from the shareholders relating to the conversion thing. Next is letter of option required to be prepared and needs to be sent to all the debenture holders. Okay, that in the letter it will be written like this debenture is going to be converted into shares. Okay, uh, so this letter of option, whether they are interested or not, this letter needs to be sent to all the debenture holders of the company, and same letter needs to be filed with ROC. And if the company is listed company, then obviously along with ROC you need to file with SEBI also. After this confirmation, when the debenture holders is going to confirm you that they don't have any objection on that, then you can allot the shares. That means you can easily convert and you can allot the fresh shares. Okay, and you can convert those debenture into shares. And obviously, whenever it is converted from debenture to shares, see, you have to change the register of charge also, because debenture means evidencing debt. Maybe you have given the debenture in the form of security while taken loan, and that debenture converted to shares now. Now what happened? You have to change the register of charge, that you have to remove that debenture and you have to provide some other security in that behalf, on that behalf. And obviously you need to cancel the charge also against that asset which created at the time of issue of debenture. And when it's converted to shares, obviously the person debenture holder who is holding the who was holding the debenture, now he is holding the share. So the debenture holder became the member or shareholder of your company, so you have to make the fresh entry in the register of the members. And after that, we need to file this return of allotment within 30 days of such allotment with the ROC. So we have to intimate to ROC about this, that we have converted this debenture into shares. That is also you have to do within 30 days from such allotment. So these are the procedures in brief for the conversion of debenture into shares. Now finally we are going to discuss about this amendment rule, that is Company Share Capital and Debenture Rules 2019. We are going to see what changes or what new things has been inserted here. So let us just check. I have inserted, I have included one table, okay, where all the changes are there. So let's get started. Like, first of all, we are going to discuss this amendment, whatever it came newly, what on which type of companies, like on which classes of companies it will become applicable. So first of all is for all India financial institutions which are regulated by RBI and banking companies. So this is all about that class, that financial institution which is regulated by RBI as well as banking companies. Here they are telling in this new amendment rule that no DRR required for both public as well as privately placed debenture. So for this, if these such type of companies, financial institution which is regulated by RBI and banking companies, if such companies um, is placing debenture, either it is a private placement or they are doing the they are giving the debenture to the public, in that cases debenture redemption reserve is not required, it's not applicable for this type of companies. Secondly, for other financial institution which within the meaning of clause 72 of section 2 of the Companies Act, that means second one, these financial institutions are not coming under the RBI or banking companies, this is coming under the Companies Act. So here also, here they are telling that DRR provisions shall be applicable as applies to non-banking financial companies registered with RBI. So for these type of companies, debenture reserve, redemption reserve provisions are applicable. Okay, so the on the financial institution which are only coming under RBI and banking companies, their DRR is not required, it's not applicable. But the financial institution which is coming under section under Companies Act 2013, their DRR provisions will become applicable. Lastly, point number 3, in case of a public issue, whenever you are issuing for listed companies, I'm talking about the companies whose shares are listed with the recognized stock exchange. For if such company is doing public issue, and if such company is a type of the such companies NBFC, that is non-banking financial companies which are registered by RBI, or any type of housing finance companies registered with National Housing Bank, or for other listed companies in case they wants to privately place those debenture, or any other companies specified any of the one or two. So for this, the new rule is telling no need to create any DRR. So DRR is not applicable for such. And point number 4 is telling finally, in case of unlisted companies, means the company whose shares are not listed with any recognized stock exchange, and such company is non-banking financial company obviously registered with RBI, or other housing finance companies registered with National Housing Bank, or any other unlisted company. There also the new amendment rule is telling like creating or constitution of DRR, okay, uh, is not mandatory, optional. Okay, if you want to create, then 10% of the value of outstanding debenture should be there. 10% outstanding debenture means whatever amount is due, there for of that 10% should be there in the reserve. So these are the new rules came. Hope uh, it is clear. And if you're having any problem or any question, you can write in my comment section. So obviously I will share the answer with you all. So thank you so much. Don't forget to like, subscribe and share. Otherwise you are not going to get the notification wherever I'm going to upload the next video. So thank you. See you soon. Bye.